Everyone. We're so glad you could join us for day 3 of the Elder Justice Conference. I'm Christy Bagalow, and I feel so fortunate to have with us today Shannon Miller and Ellen Cheek. Shannon is going to be presenting about adult exploitation, an overview and update, and I will pass it over to Ellen Cheek, who is an attorney at Bay Area Legal Services at the Senior Legal Helpline, to give a proper introduction to our speaker today. Welcome to all of you.
Thank you, Christy. This is truly my pleasure to introduce my colleague, Shannon Miller. Shannon is a board-certified elder law attorney in private practice in Gainesville, Florida. But she is also a tireless advocate who has been instrumental in every major legislative initiative of the past decade, which addresses the abuse, neglect, and exploitation of vulnerable adults. Thanks in large part to Shannon's work with a legislative group and legislative work group in 2012, her ongoing participation in a multidisciplinary group in North Central Florida, and her work with the Florida Elder Law Legislative Committee, Florida Bar's Elder Law Legislative Committee. Florida has a statute criminalizing the financial exploitation of a vulnerable adult and a groundbreaking law which provides a special protective order, a financial exploitation injunction for its most vulnerable victims. But you have to know, Shannon's advocacy doesn't stop when a bill is signed. She continues by spreading the word to lawyers and judges, to the legislature, and most importantly, to the Aging Services Network, so that we all recognize the enormous problem which financial exploitation presents and the amazing new tools designed to address it. That's why she's here today, and we're so glad that she is. Thank you for coming, Shannon.
Thank you, Ellen. My comrade in arms. As you guys all know, Ellen is always kind of the wind beneath our wings, if you will. And I am proud to come after Attorney General Moody. And what a compelling presentation from her. And I'm just thrilled to death to be speaking to all of you today, to really come right after her. She is just amazing. And, you know, from my perspective, I come to you as a practitioner in the trenches. I was a young attorney. Many of you have heard this story about Miss Maddie, who was one of my first civil clients back in probably 1996, 1997, where she had been victimized after the death of her husband by a pastor who had, seen her at the funeral for her husband and suggested that she add him to her joint account to assist her with managing finances, because it was something that she did not do very well, had never done. Her husband did all of that. And as a result of that joint account addition, he cleared out all $115,000 that was her life savings. So unfortunately, Miss Maddie came to me without any dollars to her name, and she was 92 years old. And we proceeded to file a lawsuit to try and get her money back, and learned that the law was very challenging when it came to joint account status. When you add someone to a joint account and you sign the paperwork at the bank, that really, unless you have really clear evidence that it was not your intention to have them have joint access to your account, they can clean you out at that time. So I'm very proud to say that Miss Maddie, I hope, because she did die shortly after we recovered only half of her money, she did pass away. I always think of her as dying from a broken heart of what happened. But now, we have some really great laws. And if she was alive today and had that happen to her, we would have been able to criminally prosecute that exploiter. We would have been able to asset freeze the assets that move from her joint account into the pastor's account titled with his wife under the Exploitation Injunction Statute. And now, starting July 1st, we would also be able to criminally prosecute him under a different type of statute. So many tools have come into play since that time. And I'm thinking that there are a lot of cheerleaders up in heaven kind of looking down on us and saying, yay. So I'm happy to share some of that with you today. All right. Let's talk about what the law is. And for some of you, this is going to be a rerun of things you already know from the 2014 statute changes and the definition of criminal exploitation. And the reason I start off with criminal exploitation, even though most of you are civil practitioners, is because the criminal statutory definitions of exploitation create the foundation for all of our civil remedies for civil exploitation, as well as civil theft. And I'm going to explain that in a little more detail when I go, after I finish going through the top definitions. And I'm going to try and encourage using shortcuts for these definitions, okay? So if we talk about 825.103, there are really 5, some would say 6 definitions of exploitation under that statute. So the first one, it's theft by a helper. So think of it as theft by a helper. So if I am in my 90s and I have either a family member, a care provider, someone who's assisting me, and I am vulnerable, meaning that I have some trouble with my activities of daily living as a result of aging or as a result of some sort of disability, then I potentially will meet the criteria for being unable to manage all of my activities of daily living. That's going to put me in the category of someone who would qualify under the statute. And if in addition, a helper then exploits me, then that is our first definition of criminal exploitation, theft by helper. The second definition is that our exploiter knew or should have known that I was unable to consent to either gifting them money or, I've had cases where a client bought a car at the car dealer, crashed her car going off the dealer's lot. He went back, sold her a second car. She crashed that car again. He sold her a third car within 2 weeks. He knew or should have known that he should not have continued to sell her cars. So that's our second definition, which is knew or should have known that I was unable to consent as a vulnerable person. Our third definition of criminal exploitation is bad acts by a fiduciary. And when I say a fiduciary, I mean an agent under power of attorney. I mean a trustee or guardian, or, so in that range of agent under power of attorney, trustee, or guardian, I'm going to give you some additional definitions there. This is our third definition of criminal exploitation under the 2014 statute. Let's take a minute on agent under power of attorney. This is very important. And if you have heard me give this discussion before, I apologize, but it is the most common way that we see exploitation using fiduciaries. And that is that our person has drafted or had executed a durable power of attorney. Sometimes it's done from an Office Depot or online. And that document, that durable power of attorney document, may include in it authority for gifting. So that may mean that I have executed a durable power of attorney authorizing my daughter, who we will call the agent, to gift under the terms of that document. The statute, which is the criminal statute, which is 825.103. And by the way, this is in the materials that have been provided today. 825.103 provides that an agent under durable power of attorney must act for the benefit of or in the best interest of the principal, the person giving the power away. So many of you out there remember when the first interaction you may have had with law enforcement and you said, listen, that daughter stole money from mom using her authority under the power of attorney document. And law enforcement says, well, I'm sorry, but the power of attorney document says that she can gift. It even says she can gift to herself. And that is when we point to the statute and say, yes, it does say that, but the statute does not allow the agent under power of attorney to gift to themselves because it is not for the principal's best interest and it is not for their benefit. So we remember that the statute will always trump the document itself. So even if that power of attorney says, you can take all my money and give it to yourself, or you can take all my money and give it to your family, we know that that is against the law and it is also criminal under the criminal exploitation statute. So I always like to take just a minute to talk about that because that is the most common fiduciary violation that we see, but it is not the only one. We have also had situations, and I'll just use another example. Trustees, oftentimes people will create trusts where they appoint a family member or friend or someone that they know to serve as trustee of their assets. They become incapacitated, that person steps in, and that trustee may use the monies to benefit themselves. And I will tell you a story about something that, just recently happened in Gainesville, and that was related to a, $2.1 million trust where one of the brothers was appointed as trustee, and he ended up taking all of mom's money while she was still alive. And that particular case, it's very powerful when you see that she was basically left without the ability to pay for her care. And at the end of her life, she died owing a lot of money to a lot of creditors because the trustee who she had appointed took all the money for himself. So it's, we're seeing a lot of action under that definition. And that is our third definition of exploitation. That's exploitation by fiduciaries. Bad acts by a fiduciary. And so that's our third definition. Our fourth definition was, we included this provision basically because of Miss Maddie, and that is joint account theft. So when we created this statute, we had a definition of joint accounts that was clearly being abused by a number of exploiters. So the new definition of joint account theft is that if you add someone to a joint account and they do not contribute to that account, then they cannot take the money out for their benefit. So we know that oftentimes people will walk into the bank and the banker will say, oh, the easiest way to have your daughter help you manage your finances is to add her to your account. So daughter gets added to the account. Mom becomes, unable to manage her finances, and daughter takes money out to benefit herself because she finds herself in a terrible financial situation or for whatever reason. That, in fact, is a crime under the exploitation statute. Unless you contribute to the account, you cannot use the money for yourself. So that is our fourth definition. I call it joint account theft. So let's go back over the top four. Theft by a helper. Exploiter knew or should have known that the victim couldn't consent, knew or should have known. Bad acts by fiduciaries, joint account theft. Okay, number 5 is negligent mismanagement of funds. Now, we private attorneys don't see this one very much, but oftentimes we will see it with our lower income seniors who have designated a payee for Social Security benefits. And basically that payee for Social Security either negligently doesn't use the Social Security monies for the benefit of the Social Security participant, or they just like put the checks, or they, you know, whatever they do, it's, even if it's negligent and not intentional, that again meets the criminal definition of exploitation under the statute. And then number 6 is unusual. I have not yet really seen it used. It's called a permissive presumption against exploitation. Basically, this was for sweetheart scams. So when we had an individual who was older and perhaps vulnerable, who was approached by one of our exploiters, had known the person less than 2 years, receives a transfer of $10,000 or more, there is a presumption, a permissive presumption, that the jury could find, in fact, that that was exploitation. It's a tricky, little difficult provision. I have yet to see any prosecutors use it, but it was intended for sweetheart scams. And that's our number 6. Don't use the other 5 if you can. Number 6, we love it, but I've yet to see it used. So it's out there, but those are really our 6 definitions of exploitation under the statute. I know that you guys are going to potentially have questions for me, and I want to answer them. So as questions come up in your mind, please put them in the chat, and throughout my presentation, I'll be happy to answer those questions for you. Okay. So one thing that I do want to talk about just briefly is about the exploitable brain. And again, some of you have heard me talk about the exploitable brain and what it means, but there is pretty good research, and we've got some upcoming research on the exploitable brain that that will be very helpful. Yes, please put questions in the Q&A box as you think of them. Okay, so we know that exploitation is different than, so the level of capacity that's required to be exploited is very different from what we know is incapacity as it relates to like an incapacity guardianship. Very different standards, right? There are people who are very high functioning in many ways, but they lack the capacity to make good financial decisions. And oftentimes what we see is that they then become repeated victims of exploitation. They may be able to drive a car, they may be able to have a job, they may be able to function in many ways very effectively, but they still may become victims of scams, of exploitation. And we have often wondered, why is that? What is that? What's going on in that exploitable brain? So let's talk for a minute about that. And we know that there's a study that was done, I think it was 2012 that the study came out. There's actually 2 really important studies, but the most important one in my mind is the one where we had about 26 people that were exposed to the scam, and half of them, 13 of them, took the bait. The other 13 did not take the bait. So they were all subjected to the scam, but only half, 50%, actually became victims of the scam, and the other half did not. They resisted. They assessed whatever they needed to, and they resisted the temptation to, you know, send money to the exploiter. Of those that fell victim to the scam, they put them under MRI, and what they found in 100% of those MRI cases was a thinning of the cortical insula in the brain. It's like above the temple, behind the ear, just right about here on your brain. And that thinning of the cortical insula has become somewhat attributable to this idea of risk assessment. So if I am exposed to that scam, I may not be able to assess the risk associated with that. So what that can mean, and it's been explained to me by our researchers, that if I'm looking down the street and I see something shady ahead, so I see like a street light lamp is out, There's some people that kind of look nefarious, kind of moving in the shadows. What I might do is I might turn around, or I might move across the street. I'm not going to keep walking on my path directly into that dangerous situation. The person with the thinning of the cortical insula cannot assess that risk, and they will walk straight into that situation. And the same is true with, risk assessment as it comes to finances. We know at the age of 53 or 55, depending on your gender, you're at your height of financial acuity. So you're going to make the best financial decisions of your life really between the ages of 53 and 55 years old. From there, we start to see this decline. And for those of us that have a thinning of the cortical insula, that decline becomes more pronounced. And we know as we age, we will start to see that thinning in general. So we lose the ability to assess financial risk. And what we also know from the research is that there's an increase in trust. So that means that if I'm a person who, already kind of can't see very well, I can't hear very well, I can't assess risk, we also know that when you take out all of that and all you're assessing is whether or not they are more trusting, we're seeing an increase in trust. So it's a perfect storm for exploitation. We have a decrease in the ability to assess risk. We have a decrease in financial acuity. We have an increase in trust. We have a decrease in eyesight. We have an increase in isolation. We have a decrease in the ability to hear. And exploitation results. We know that some of the statistics tell us somewhere between 20 and $40 billion a year is going out the door to exploiters in the United States alone. That is a lot. And so we know that really it's probably more than 20% of people have been exploited, but we know at least 20% of people over the age of 70 have been exploited when they're just falling victims to scams on the internet. Those types of exploitation on average will see a victim lose $17,500. When we're talking about exploitation among family members, that number jumps to somewhere between $50,000 and $52,000. The average number of times that a victim is exploited is 3 to 7, depending on whether it's an unknown person who's the exploiter versus a known family member. The number increases. So we're talking about really an epidemic, and I love that Attorney General Moody is really drilled down into this problem. And I also am just thrilled that we recognize that Florida is perfectly equipped to address these issues, and we have done so. So we've talked about the exploitable brain a little bit, and now we're going to talk a little bit about our second tool in our toolkit. The criminal exploitation statute, we now understand, has 5 or 6 definitions of exploitation. What do we do with that? What do we do with these criminal definitions of exploitation? Well, there's 2 things that we can do. Actually, there's 3 things that we can do on the civil side. The first one, and I think the most important one, and the one that the last time I went to talk to a group with Seniors versus Crimes, it was in the Villages, and it was right before the lockdown. And we did a little session on using civil theft, which is Florida Statute 772.11, that relies on the definition, the criminal definition of exploitation, to allow us to create a treble damage recovery. So civil theft is by far the most effective tool we have to recover assets in a very quick time period. And that is, you have to send a notice to the exploiter. And I know what they've been doing in Seniors versus Crimes, which has been very effective. When someone what they've seen a lot of is where someone will knock on the door and say, hey, you have a problem with mold, or you have a tree that needs to come down, and they're an unlicensed contractor, and they require payment up front of like $8,000 to $10,000. and then they don't provide any service. And so or they provide bad service. And so what we know that Seniors versus Crimes is doing in those situations is they're helping the victim by sending a civil theft demand that says, hey, you need to give me my $10,000 back or I'm going to sue you for $30,000. And again, we go back to that definition of exploitation, the criminal definition of exploitation. And in this case, it's likely going to be knew or should have known, which is our second definition of exploitation, that the person was unable to consent to that agreement. And we have a criminal definition of exploitation. We use the civil theft statute to get that money back quickly. And I know I told you guys earlier about the car dealer case where we had, okay, I will. We had the lady who purchased the Cadillac and drove off the lot and crashed it, and then got a second Cadillac and drove off the lot and crashed it, and they sold her a third one. We did a civil theft demand in that case, and we got all her money back. And it was done super quickly and super easily. They understood because during the civil theft demand, you actually have to give them notice as to why it is you think they violated the statute. So you kind of make it really easy for them to see. And then oftentimes they'll just write a check for the full amount that's due. And that person is made whole without having to file a lot of litigation in the case. But in some cases, we end up doing, having to do an actual civil litigation case. And in those cases, when you are looking for attorneys to represent you, and that's private practitioners like our office, we oftentimes will take a case where we know we have a deep pocket and there's treble damages to recover. We may take those cases on a contingency. By using the civil theft statute, we can recover triple plus attorney's fees, which is awesome, against this exploiter. And so it makes our remedy really great. And you're going to see that attorneys will take on a case where there's really no money with which to pay that attorney, as long as you've got a good civil theft demand that you can either have that attorney issue or that you've done before bringing that attorney in. You may find that you can get private attorneys to take on these kinds of cases. And we do that regularly in working with guardians or working with adult protective services who might bring us those cases. And then we can, really be able to recover some significant assets on more than what the victim lost. So it's a great tool. I encourage you guys to think about civil theft. And one thing that I want to really, kind of drill down in a little bit is consent, right? So this is by far the biggest defense that we get in these cases. And that is that our little lady who drove off the lot and crashed several times, but kept consenting to, buying new cars. Consent is not a defense in these cases. So, oftentimes the defense that we hear again and again is that she wanted me to have the money. She wanted to give me the $110,000. And when we're talking about vulnerability and we're talking about victims who are vulnerable, consent is not a defense to exploiting someone. So I wanted to make that clear, and thanks for reminding me of that, Ellen. Okay, so let's move on to our second tool, because this is another tool that I think can be very useful to you guys. And you guys are super quiet in the chat. I'm hoping that everybody's out there. So ask me any questions you have about anything. If you need clarification or have any questions about defenses or those types of things, please take this opportunity to ask those questions. Okay. So what is the exploitation injunction and how does it work? The exploitation injunction came into play in 2017. Actually, it became effective in 2018. It was during the 2017 legislative session. And that statute is 825.1035. That's the exploitation injunction statute. And again, another groundbreaking tool that really we think we were the first state to do it. I've heard some other states have done something similar now. But what that tool does is it allows a victim without being represented by an attorney. They can actually go and file an injunction themselves, or a helper can do that for them, as long as they have consent. And we're going to talk about the Attorney General law in just a minute, because we even have a new layer to add on to that. But basically, the exploitation injunction statute allows that victim to file an exploitation injunction in court, ex parte, meaning that you don't have to tell the defendant in the case, the exploiter, about the filing of the petition. It's done without notice to the person who's alleged to have committed the exploitation. What these exploitation injunctions do is the judge reviews the facts. So, obviously you need to have sufficient sworn evidence. And usually that can include things like bank statements. We can actually attach affidavits from people who witnessed the exploitation or who have knowledge of the exploitation. And then those are filed with the court ex parte. And it's been my experience in several circuits in Northern Florida, and Flagler as well, that the court will review those injunction petitions and enter an order, usually within 24 to 48 hours. And what the order says is, we're going to freeze that account of the victim. And sometimes we're going to freeze the account from where the victim's assets have been moved. So we talked about Miss Maddie at the beginning and the pastor. What would happen today is I would say, Your Honor, here's the bank records that show the account number and the location of where these assets were transferred. We would like to have the court freeze not only our victim's joint account that has no money in it, but also we would like the court to freeze where we can show these assets were relocated. So we can actually freeze both of those accounts. And I know you guys are going like that's so awesome. Yes, we can do that. You just have to provide that evidence in your initial injunction petition. Okay. So once that happens, those assets are frozen. And here's the kicker that I love. This is I just love this. In addition, you can require that the court create a no contact provision with the exploiter. Because what we know is that oftentimes our victim is being unduly influenced by our exploiter. And so, I always just use real facts scenarios that we've come across. We had a case where a neighbor was exploiting this lady, and he had, she signed deeds over to him. She added him to her bank accounts, and we filed our injunction petition because in addition to all of that, he had there was a fence around her house. He created a new lock, and only he had the key. So basically he was able to completely isolate her and prevent her from having access with her family members, who were also her agents under power of attorney. So we went into court, we filed our injunction petition, and the court entered an order enjoining, freezing the bank accounts, but also creating a no contact provision for the neighbor. And we were able to kind of access the victim. The family was able to come in and see her again and talk to her and show her what had happened, what the exploiter had actually been doing without him influencing her. And it was so effective, because once you take away that undue influencer who has isolated our person and who has really, kind of created this situation where our victim is no longer thinking freely. They are completely under the influence of our exploiter. If we get rid of that person, that means no phone contact. That means they can't be in the home. That means they can't have any access to them until the court resolves in a second hearing the injunction that's been filed. Okay, Christy's coming on, which probably means there's questions.
When my head pops up, there's questions. This is such great information. We've got some good questions here.
Awesome.
First one is, can you walk a little more slowly through the consent is not a defense issue? I think I'm confusing that concept with the need to prove diminished capacity.
Okay. let's do it with a scenario. We know that our person is vulnerable, okay? And what that means, and I'm going to share the screen for a second, because the important definition is, hold on, let me get here. Actually, I'm not going to do that because we're going to get too in the weeds if I do that. 415.102 gives us the definition of, basically all the definitions that we use under 825.103. And so when we look at Florida statute 415.102, and I think it's in the materials, it's going to tell us when a person is vulnerable. And so once we reach that threshold, consent is no longer a defense. So if we have a vulnerable person, it's just like you've met your threshold. So like in a case where you had a child victim in a criminal matter, even if that child victim consented, that is not a defense. It's similar to that scenario. And I know that that's very hard because sometimes what we'll say is, well, diminished capacity versus incapacity. Forget about capacity because capacity is not part of the definition of a vulnerable adult, nor is it part of our definition of, and I don't want to misstate it. I wish I had the statute in front of me, but it's elder. So someone who qualifies as an elder. And so, I don't know if that helps you, but I would be happy to talk more offline about this issue of consent, because I think consent is often raised as a defense in these cases. And one of the things that I do when I go into court, and that's been raised, is I point back to the statute and I say, Your Honor, the statute requires the following elements. And so in the case of like a joint account, right? What the statute says is, have they added a person to the account? That's our first element. Our second element is, did they contribute to the account? If the answer is no, then we've met our second element. And then the third element is, did they use the assets for their own benefit, that were not either for the benefit of the principal person putting the money in or for their best interest for some reason. And if you've met the elements of the crime, nowhere does it have in the legislation, in the legislative intention, that consent would be a defense. So the key is really to get your judges not to go down that rabbit hole of consent and trying to assess capacity. All that you need to focus on is the vulnerability of your victim. And then you just hone in on the elements. And I know it's a challenging issue. So I'm glad that you've raised that, because I think that's something that a lot of us struggle with. So
great questions. And I think you answered another question. How do you articulate to a judge that consent is not a defense? So you just went through that. Go to the statute.
Yeah, it's hard. And I think part of it is just education, really like, and not trying to, I know when I go into court, because I go into court a lot, I try not to go in like thinking that the judge doesn't know about what's happening in our world. I mean, judges are human, and exploitation in our state is so prevalent. They probably get text messages about, you're going to be arrested if you don't pay me $20 for your Medicare card or whatever it is. Everybody is exposed to scams, and everybody knows somebody that's been exploited. That is a change from 1997. Now we have people who very much on the bench want to prosecute these cases. So give them a reason and stick to your guns. Like, just because you have a pro se litigant doesn't mean that you have to, agree that consent is a defense. And they have the burden of proving that consent is a defense after you've proved your elements. So I would stick to that. I would say, look, Judge, we're here. We're here to show vulnerability, and we're also here to show the elements of the crime. Consent is not a defense. And just keep saying that. And if the judge says, well, I don't know, I think consent is a defense. Your Honor, they have the burden. They come with some case law. Show me where consent is a defense. So yeah, I would definitely encourage you guys to do that.
Okay, great. Do you have any statistics about how often these cases are being filed, like the criminal cases?
I do not have any statistics on that, but I will tell you that I had a lot of trouble getting these cases filed. I had a lot of trouble getting prosecutors to prosecute them. But I will tell you, we've had a 100% success rate since Attorney General Moody and Karen Merlo have taken the bull by the horns. When we have asked for prosecutions of these cases, they're happening. And
Great.
I'm accustomed to being like shut down, and like now we meet with prosecutors. And I know that's one of the things that I wanted to talk about a little bit. How do we get cases prosecuted? So let's get to that, because I know that might be helpful to address some of these questions. Okay, here's what I do. I've got my facts. I've got my injunction in place. So we just had we filed our exploitation injunction. So we've been able to freeze the assets. So no more money is going to go to our exploiter, right? And we really would like to avoid doing a protracted civil litigation case, because as we all know, it's very expensive to do. But if we have to do it, we can, because me, private attorney, I want to prosecute these cases because it's treble damages and I get attorney's fees, right? So I'm happy to prosecute your case, but it's going to take time. We're going to engage in discovery. We're going to have motions for summary judgment. We're going to do deposition. It's going to take a while for me to get my case prosecuted. What a better remedy to have it criminally prosecuted, and then you just deal with restitution in the criminal case. But you have to get your prosecutors to buy in that this was criminal conduct, and that this exploiter is in fact a criminal and not, a civil matter, not a family law case. So what I do is I get all of my evidence. I get my certifications from the records custodians of the bank records. I've already pretty much done that for the exploitation injunction matter. And I wrap it up in a bow, and I don't just, send my client over, my victim or their agent under power of attorney. I, as the attorney, ask for an appointment with the prosecutor. I actually have on occasion, and actually in the last couple of months, I've gone directly to the state attorney in 2 different circuits and asked for meetings with them. And in one case, I met in person with the prosecutor, and he was like, we are going to do it. Yes. I brought him in. In that case, we had actually already filed a civil case. So we filed a civil complaint. I brought him the civil complaint. I brought him all the bank records. I brought him everything that he might need to prosecute the case. And he was like, yes, I'll do it. And I think what we're seeing in some of the bigger, remember, I'm in North Central Florida, so our circuits are pretty small. We don't have designated prosecutors doing these cases, although we're getting there. And I know you guys, if you were on yesterday, you heard from Heather Jones, who's in Gainesville, and she's amazing. So we are starting to get, even in smaller circuits, some prosecutors who are really driven to do these exploitation cases. So, package it up, make it easy for them, meet with them, don't send your victim, and go directly to prosecutors as opposed maybe to law enforcement. Although now there are really good educated law enforcement officers who may also be interested in these cases. What happened in the $2.1 million case that I talked about earlier, and you guys, I want you to know, we brought that up to our new state attorney in the 8th Judicial Circuit, like literally in the middle of January. That case was prosecuted, like executed search warrants to the exploiter's house, like all this stuff. Literally, it happened in the blink of an eye. Like all of those things were done, all the investigation was done in less than 2 months. So, you know, these things can happen rapidly. Once you get a good law enforcement, we had a really good investigator assigned to us from the Gainesville Police Department, a detective. He was amazing. He like jumped on it. He was like getting all the records. He like had done surveillance. I mean, it was amazing. So, you know, it can happen. Of course, that was a bigger dollar case. Sometimes we have smaller dollar cases, like the cases that I've been talking about in the Third Circuit, where, you know, we were able to do the same thing, was to get a prosecutor involved. So you've got to package it up and make it really easy for prosecutors to do the case. But I would not send victims. I would take the bull by the horns ourselves as, you know, educated practitioners, pull your statute, highlight it, highlight the definitions in 415.102. You know, I have a raggedy copy of those that are underlined and highlighted, and I pull it out every time I'm talking to somebody about exploitation. I have it highlighted and I pull that out when I'm talking to prosecutors, because part of our job is to do the education. People can't believe that these are the definitions of exploitation and that consent is not a defense. So you have to be an educator with patience, and also realizing that nobody likes exploitation. Everybody's seen it. And what we just have to do is speak their language and really kind of come clear with what our laws are doing today. Which brings us to our next, and I know there's a couple more questions in the chat, but I think what I really want to make sure that we get to is the Attorney General legislation. My heart. Okay, so I'm going to share the screen now and talk about this legislation. Okay, here we go. Okay, first of all, the good stuff. You know, this was a bill, again, Colleen Burton, she's been a champion for us doing exploitation stuff. And Senator Burgess is, you know, right in the mix now. So we have some really strong advocates at the legislature dealing with exploitation advocacy. This is actually the combination of 3 different bills. And I want to highlight a couple things here. These are the key provisions. And you guys, this is part of your materials, but I bring it up because it's really important for you to know some very important things in this law. That's, I mean, obviously it still needs to be signed by the governor, but we're pretty confident that that's going to happen, and it will become effective on July 1st. The statewide prosecution of exploitation cases, huge. So when you go and sit down with that prosecutor and they decline to take the matter on, that's when you might want to, you know, have the statewide prosecutor take a look at your facts and your case. But again, package it up, send it with a beautiful cover letter, highlight the statute, make sure that your facts are what you say they are, because once your credibility is gone, you're never going to be able to get that audience again. But the statewide prosecutor can do 825 cases now. So that, well, as of July 1st, so that's huge. This is also another provision, and it says prevents abusers and exploiters from inheriting from those they exploit. And the nice thing about this, we call this the exploiter disinheritance statute. This used to be one part of the proposed legislation that we tried, the elder law section tried to have passed for the past couple years. We haven't gotten anywhere. So this is beautiful that it's now been wrapped into this statute. But it can change how you proceed with your civil cases. So this basically says if you have a conviction for exploitation, then you cannot inherit under someone's estate. So for example, in that case that we were talking about, where a trustee was an exploiter, they're still a beneficiary under the estate or trust of that victim. So if this law had been in effect, or potentially if they're convicted under this law after July 1st, then potentially we could use the statute to disinherit that exploiter if they are convicted under the 825 exploitation offense. So you don't want a deferred prosecution. You don't want them to plead to regular theft. They need to actually have a guilty plea. And so we need to kind of educate our prosecutors that, also there may need to be some kind of plea as part of the plea colloquy. They may need to say, like, you understand when you enter a guilty plea, you're also aware of, Florida statute, and I'm not sure what our statute number is, but the new statute that's coming into play, that you're also, potentially going to be disinherited under the statute. So it's great because once they're convicted, they can't then inherit from the person unless there's an affirmative act to re-include them in the estate plan of the victim. Criminalizes kickback. So we also know that there's been some bad actors out there in Florida who actually are visiting facilities and providing some kickbacks for referrals that end up with pretty shady stuff with exploitation involved. So this actually criminalizes the kickback for that purpose. The intentional isolation, this is something that Attorney General Moody talked about earlier, that you just can't do that. You can't isolate people. And I always say, the lies. So they whisper the lies as part of the undue influence. They say your kids are trying to put you in the nursing home. Your children have stolen money from you. Things that even aren't true often happen when an exploiter gets their hands on a vulnerable adult. They just repeat, and they do it with such intensity and with such frequency that becomes the truth. And remember, we know with the exploitable brain, the thinning of the cortical insula, people can't tell the difference between the truth and a lie. So, okay, this is again a part of our perfect storm for exploitation. So that intentional isolation from family members can also be criminally prosecuted now, and this is actually not in 825.103, but it's in 825.102, which is the elder abuse statute. So we love that. We love that too. And then, this criminalized intentional modifications of someone's estate plan. I told you guys about our case. Well, I haven't told you guys. We have a case where this lady, got access to the joint account and used our client's money, and also had some, did some other stuff. So she got like $260,000 from our victim. And she also took him to an attorney and had his estate plan changed. And so, we can undo everything. We can, we did our injunction, we did our civil case, we've recovered all of his money for him. But she's still the beneficiary of his estate plan. It's insane. So this is like our last needed dot the I and cross the T. We also need it to be a crime if you take someone and unduly influence them into a new estate plan. And many of us who work in the field, we're like, of course that should be part of it, because that's always part of the exploitation event. It's always part of the exploitation event is also getting a will off the internet, or, finding an attorney who might do it for you without asking too many questions, or they don't separate the victim, or the exploiter is so good at the undue influence that the victim actually can say to the attorney, this is what I want. And they may have a list, or they may talk on the phone with the exploiter in the background, telling them what to say. So, this is really icing on the cake, because there are no states in the United States that criminalize this type of undue influence for purposes of estate planning. So we're really happy about this. This is going to be awesome to help protect our people. And then, this last part, which was a separate, again, we've tried over the last couple of years to include this provision. When we passed, and this is an authority for an agent under power of attorney to file an exploitation injunction. And so we talked about exploitation injunctions a few minutes ago. But when the statute became effective, when we were actually at the legislature, we got some pushback on agents under power of attorney being able to file exploitation injunctions for our victims. And, frankly, that was because there was some fear that agents under powers of attorney, it was like kind of a lower threshold to become an agent under power of attorney, and that it might be abused. And, we really haven't seen anything like that. So at this point, we think that this allows us to file these cases without having to set up a guardianship. And in many cases, what we find, unfortunately, is that when a victim is being unduly influenced, and I told you that case about the neighbor who had really isolated our lady. And so, we had to set up a guardianship in that case because our victim was incapacitated. She wasn't all there. And so we ended up having to set up a guardianship at the same time that we file our exploitation injunction. And the cost of that is huge. I mean, guardianships in general are costing between $7,000 and $10,000. So if you're a lower income or lower asset victim, you're not going to have access to the exploitation injunction if you're incapacitated. This really changes that. This allows agents under durable power of attorney not only to file these cases in court, but to file these cases in court without the consent of the victim. And that's huge. I always talk about, this undue influence, and really it's like a trance, like our victim is in a trance over the exploitation and the exploiter's lies about, they're stealing from you. They want to put you in a nursing home. They want to take away all your rights. So oftentimes we can't get the victim's consent to the exploitation injunction, even if you can show the victim proof that the exploiter has stolen all their money. They really have this kind of attachment to the undue influencer and the exploiter. So under the new statute, the agent under power of attorney can file an exploitation injunction even if the victim is not consenting to the filing of that document. So it's huge. Okay. And that is, for the most part, the rest of this, which again, this is in your materials, but that's really the highlights of the statute, the new statute that will come into play in July. And so let me just look at my little outline here and see what else. Right. So, here's one thing that I want to encourage everybody out there to do. If you don't have an elder law attorney connection, get one. Get one. Because if you have an elder law attorney who also does some litigation, even if they do this litigation light, right, where they're just doing exploitation injunctions and doing the civil theft demands, they may be willing to do these kinds of cases on a contingency basis. So you may have a victim who qualifies for legal services, but they don't have any money, because their money's been stolen. So they're going to qualify, but you can't get a private practitioner to do this work for you because they want to be paid. Well, you might be able to get a private practitioner to work with you on these cases because, number one, they may be okay with waiting to get paid until there's a recovery. They may be willing to do it on a contingency. And again, oh, well, we don't want to take a third of the victim's money. Well, if you do the civil theft and you've got treble damages, then you're actually not only going to get treble what the victim had stolen from them, but you're also going to get your attorney's fees paid. And by the way, the injunction petitions, there's no filing fee to file those cases. So, what we've seen is that it really creates access. You don't have to have an attorney and you don't have to pay a filing fee. Also, the elder risk detector, which I know has been talked about, and it's in the chat. The link, the link has changed. It's a new. It's kind of going through Department of Elder Affairs now, but right now there may not be the injunction petition builder in the elder risk detector, but it's coming back. We had it there for a while. We're doing some upgrades to the site, but the injunction builder is coming back. And again, you just plug in some information into the injunction builder and you have a petition ready to file. So the injunction builder is really helpful. Also, the handbook is also super helpful. And there's also a webinar on the elder risk detector site to walk you through the exploitation injunction and how to prosecute those cases. And just give some basic overview of how to prosecute an exploitation injunction case. So that is really helpful. But again, working with an elder law attorney, if you have questions or you want to email them, like, here's what the durable power of attorney document says. Can you help me to understand this provision? Or, it's a trustee case, or, whatever it is that you come across, forming a relationship with an elder law attorney who has prosecuted these kinds of cases can be really helpful to you. And, I also like to be a resource. I may not get back to your email right away. Usually it's the weekend before I respond, but I often work together with prosecutors locally. I have several contacts in Seniors versus Crimes who ask questions. Elder law attorneys, you'll find, are very accessible. They want to be helpful. And sometimes they get a case out of it. And so then they're really happy because you've become a referral source for them. To actually, be able to recover a fee in doing these cases. So that was one other thing that I wanted to bring up. Talk to prosecutors. Be willing to educate them, and really educate yourself first. Become super familiar with the statute. Also, remember the Florida Senior Legal Helpline, and I think that number is also in the chat. 888-895-7873. That is a great place for referrals to local legal services programs. So I want to encourage that as well. Now I'm going to keep talking, but I think because Christy has come back on that there's probably more questions. But when we have extra time, do not worry, because I'm going to fill it with more information. So Christy.
I didn't want to forget about these questions. Such great information. And it's so nice to hear when Florida is ahead of the curve and that we're ahead in protecting seniors. That's great to hear. Okay, so a leftover question from last time regarding the permissive presumption. Is that a separate exploitation or a presumption that you can use with the other 5? It appears in the jury instruction as a statutory inference. Was looking for clarification.
Oh, the permissive presumption of exploitation. So this was actually created out of Senator Pasadomo, who's about to be the head of the Senate. She really loved this permissive presumption against exploitation. And it is, it's unique. I mean, have you ever heard of a permissive presumption? And so I think if there are any prosecutors out there, they're probably like, what? What is a permissive presumption of exploitation? Basically, if you meet all the elements, the way that this is supposed to work is that once you meet the elements, it goes to the jury as something that they can find exploitation, but they also can say, no, it's not exploitation. It's kind of like, I likened it from the law review article that was written on this. I likened it to kind of like pornography. Like, you kind of know it when you see it, right? So I think this is the same idea, that, really, you know it when you see it. And so the elements are pretty clear. It's like, you've known the person for 2 years or less, $10,000 went from person A to person B. And, usually it involves some sort of weird sweetheart scam, but I can tell you when I think it would be effectively used. And that is when you have a history of this exploiter doing it to other people. So, we have a case right now that involves very similar facts, where a caregiver is now the owner of a lot of real estate of the victim. And she knew him 6 months before he died. So, it's like, it just doesn't pass the smell test. And so, this came out of a law review article of a gentleman, I think he's in Tennessee. I can't think of his name, Professor something or other. And he's a law school professor. He wrote this law review article about what happened to his father in one of these sweetheart scams in Florida. And he actually reached out to Senator Pasadomo and showed her his law review article. And so we were like, why not? Let's try it. But I think prosecutors are a little gun shy. I haven't heard of one yet. So if you all hear of one, please let us know. But I mean, that's the idea, is that it's not a presumption, it's a permissive presumption. So yeah, the jury instruction is out on it. And it does seem to be kind of an inference, but I don't know that I don't know how it's going to work. I just haven't seen it yet. And I've not used it in the civil practice. We haven't needed to, because we have these other 5 pretty solid ways of doing these cases. And let me give you guys, as civil practitioners, a couple of other pieces of ammunition that we often use when we're doing these cases civilly. And one of them is unjust enrichment. One of them is just plain old theft. If you have a situation where someone died, we use intentional interference with an expectancy that gets us a jury trial on the case. So, there are a lot of different causes of action that we can use. Also, civil exploitation. Civil exploitation, I caution people because it uses the definitions of exploitation before the 2014 changes to the criminal statute. So under Florida Statute 415, which we know is really the Adult Protective Services provisions, it uses a lot of the old definitions of exploitation. So when you're doing a civil exploitation case, which has the added benefit of punitive damages, but not treble damages like you're going to get with civil theft, the civil exploitation, the definitions are harder. Don't forget that you have to sometimes prove things like that the intimidation, and it's like you have to show intimidation and duress by the exploiter, which makes proving the case a lot more difficult, because as we know, exploitation doesn't happen on videotape. It's always done behind closed doors. It's always a circumstantial evidence case. You're never going to have a direct evidence of the exploiter telling the person lies. You just won't. They just are very private about it. They do it in secret. So it's very difficult to show things like intimidation because you don't have direct evidence. And if that's your standard, I mean, that's really what prosecutors, when we wanted to change the criminal statute, let's see, Lisa Chitaro was like, we can never prove these cases because, it's always done behind closed doors. So that was one of the things that we really wanted to take out of the 415 statute when we were making changes to 825. We just didn't change the statute in 415. That might be another glitch bill that needs to happen. But unfortunately, that's what we're stuck with at this point. Christy, I'm feeling like you have another question for us.
I have another question.
All right.
Someone was asking how to defend against consent not mattering. For example, if there's a good reason for consent, such as a parent wants to cover an adult child's expenses during chemotherapy, or allow a joint account holder to cover expenses because that person has been injured while helping the elder. Do you have any advice for that?
Yeah, I do. And I'm going to give you the practical answer. And that is that I have not yet found a prosecutor that is going to take a case where a parent is trying to provide legitimate expenses for the benefit of a child. If they have a long-standing, I mean, if you guys look at Florida Statute 709, there is a way to use a power of attorney to gift if you show a history of gift giving, if it's clear in the statute. There are historical ways to prove that the parent would have wanted to make these types of gifts. And frankly, prosecutorial discretion has always been something that is exercised with, in my opinion, great deference to the intents of our seniors. So, if I'm defending that case, then I'm always going to advise people, if there's any way to do it without taking money from someone who's vulnerable, please find other resources. But if it's the only option and the senior really wants to make that type of gift, a lot of times I might say, let's just do a guardianship and have the court approve it. You know, if we can set up a guardianship and petition the court for approval under Florida Statute 744, that may be another way to protect that type of distribution, even if you did a voluntary guardianship. So they may be competent to establish a voluntary guardianship, but then you can have kind of court oversight to protect against some sort of criminal prosecution. But I would say in most cases, we have enough trouble getting prosecutors to prosecute the really bad, egregious cases. You know, you don't want to advise people, oh yeah, go ahead and gift to yourself. But they're just not really looking for cases like that to prosecute. So yeah, I hear what you're saying. It's tricky, right? We're kind of like on a tightrope. We want to honor the independence of our people, the age. Like we want to make sure that we honor their wishes at the end of their lives. We want them to be as independent as possible and to direct their own affairs as much as possible. But at the same time, we need to protect them. Exploitation is out of control. It is, in my mind, it is the number one problem that I see with regard to family members and seniors and people who are vulnerable, more so than even things like, you know, making end of life decisions. Exploitation has become much more, it's just, it happens all the time, scams and it's just become out of control. So we have to challenge ourselves to maintain that independence, but also to protect. And so we have some tools, some really good tools. I was actually in California these last few days, and I heard a story about a case out of Minnesota. Typical facts. And they were powerless to deal with this exploiter. He'd exploited 3 different people. And I was like, well, an exploitation injunction. They're like, we don't have that. I'm like, well, your laws clearly protect somebody from a joint account theft. They're like, no, we don't. And I'm like, you guys, I'm going to send you our statute. You need to implement this because we really are lucky. We have these tools. We need to use the tools now, and we need to educate on the tools.
We have one last, a very intriguing question. Have you ever worked with clients who are undocumented? Has anyone's immigration status ever been an issue in these types of cases?
Yeah, I have not had that experience. However, you know, I will tell you, if our victim is undocumented, you know, I am still going to, you know, try and be an advocate for them. It may depend on the jurisdiction that you live in, but for me, you know, I may try and do some kind of feeling around first before I disclose an attorney-client privilege communication. Obviously, you know, is this going to create problems for my victim that are worse than the exploitation? You know, I hold attorney-client privilege to be a sacred creature, and I'm not going to disclose anything unless I'm sure that I'm not creating something worse than the exploitation event. But yeah, I'm going to do that advocacy. I know it's hard, you guys, but we've got jobs to do.
For questions, did you have any last remarks in the last 2 minutes?
You know, keep doing this. It's like I never thought that we would get from where I was with Miss Maddie to today. I've got some other clients up there who, you know, one of Mr. McCadden, who was our case before the exploitation injunction came down, one of his dying wishes was for us to talk about him and talk about his case and talk about his daughter stealing all of his money. So, you know, we've got a cheerleading squad somewhere and it's working, but we just have to continue to work. We have to continue to make new laws, and we have to continue to use these laws because they are powerful tools in the fight against exploitation.
For all that information, it was heartbreaking to hear what happens to seniors, but uplifting to know that there are tools in the toolbox. So that's at least a positive note to end on. I did want to let everyone know that there's a short survey in the session notes, so please complete it and let us know how wonderful Shannon was. So hopefully she'll come back next year for the conference. And for the 2:30 sessions, you have a choice between predatory practices and scams or supported decision-making. So I hope you can join one of those. Thank you again so much, Shannon, for doing this. I appreciate it. Great
Thanks for having
information.
me. And this is such a great conference. I've so enjoyed it.
Fantastic. We are just glad that the technology is working. Bye, everyone.